Hi everyone. Today let us discuss ESI Act. The various benefits under the ESI Act 1948, the section 46 to 47. The very important question. So let us discuss regarding ESI Act. The first introductions. So the Employee State Insurance Act 1948 is a social security legislation. The objective of this act is introduce social insurance scheme with a view to provide certain benefits to employees. The scheme spreads to health, maternity, and accident insurances. It is a compulsory state insurance scheme to which every employee must contribute a prescribed sum of the money. Right now, the employee is contributing 0.75% and employer contribution is 3.25% at present. Earlier, that was 1.75 employer contribution. 1.75 employee contribution and employer contribution was 4.75%. Okay. The various benefits under this act so clearly shows that the act is a social security legislation. So various benefits under this ESI Act, let us discuss friends. The Act provides for 6 types of benefits. So section 46 to 58. Benefits to which the insured persons, their dependents and certain other entitled persons only. That is very important. Employee can claim benefits and their dependents like father, mother, wife and children. So then claim benefits. That is very important. There are total 6 benefits, friends. Sickness benefit, maternity benefit, disablement benefit, dependence benefit, medical benefit, and funeral benefits. Okay. First, let us discuss sickness benefits. Section 49 defines that sickness. What is sickness benefit? An insured person is entitled to claim sickness benefit if he had paid contribution for a period of not less than 13 weeks. He has to work 13 weeks without any variance. For sickness occurring during the first benefit period, he can claim sickness benefit if he had paid for half the number of weeks of the contribution period, ending in the end period. For example, more than 26 weeks in the 1 year period. There are two categories of there are two types of period here. One is contribution period, another one is benefit period. Contribution period is April to September and October to March, and benefit period is Jan to June and July to December is the benefit period. So, a duly appointed medical practitioner must certify that issued person is suffering from sickness. The daily rate of sickness benefit is calculated by a ratio between his average daily wage and the contribution period. For example, an employee earns rupees 100 per day. The standard benefit rate under the scheme may be 5,000 rupees. The insured person is not entitled for sickness benefit for the initial waiting period of 2 days. But if sickness recurs within 15 days, he can get the benefit for the first 2 days in the second sickness benefits. Sickness benefit is not payable for more than 56 days in any 2 consecutive benefit periods. The daily rate at which the benefit is payable to a person for the period of sickness is the standard benefit rate corresponding to the daily average wages during the corresponding contribution period. The following contributions are to be complied with to entitle to sickness benefit. Section 64 defines like this. The person must be under medical treatment at the dispensary, hospital or institution provided under the Act, must carry out the instruction given by the medical officer. Number 2, while under treatment, he must not anything which might reduce his chances of recovery. Third one, he should not leave the area without the permission of the medical officer. He must allow himself to be examined by any duly appointed officer authorized by the corporation. Waiting period in sickness benefit under ESI Act. Sickness benefit is not payable for the first 2 days of a spell of sickness except in case of a spell commencing within 15 days of closure of earlier spell. for which sickness benefit was last paid. The period of 2 days is called waiting period. Next, second one, maternity benefit section 50. An insured woman can get maternity benefit in cases of miscarriage, confinement, sickness due to pregnancy, and for premature birth of a child. The grounds of eligibility of an insured woman to such payments must be certified by an insurance medical officer as provided by the regulations under the Act. However, payments will be made only to the duly appointed medical practitioner. Even for expected confinement, she can avail this benefit. However, she should have paid weekly contribution for not less than 13 weeks. All the other rules are similar to the rules in sickness benefit except that her standard benefit will be doubled. For example, if the wage of a woman is rupees 100 per day, she will get rupees 1000 rupees daily as maternity benefit. The maternity benefit is not available for more than 6 weeks during her confinement. So, if the insured woman dies leaving behind a child, the maternity benefit is paid for the whole period. If the child also dies, the maternity benefit is given to the woman worker's nominee. If there is no nominee, it is paid to her legal representatives. Next, disable benefit, section 51. Disable benefit is payable to the insured person if he suffers some disablement. Second one, the disablement result from an employment injury. He sustained the employment injury as an employee under condition mentioned in the Act. The disablement benefit is payable only when the injury is duly certified by an insurance medical officer. The employment injury means that the injury must have arisen in the course of employment or out of his employment. It may be by an accident or occupational disease. Liability of the employer. The employer is liable for employment injuries happening while traveling in the employer's transport or happening while meeting emergency also comes under the terms employment injury. So, traveling in employer's transport section 51C. The liability of the employer arises only if the following conditions are complied with. So, first one, an insured person must be traveling by any vehicle with the express or implied permission of his employer. He must be going to or coming from his place of work. So, number 3, the vehicle must be operated by or on behalf of his employer or some other person in pursuance of an agreement made with the employer. So, one more point, the vehicle should not be operated in the ordinary course of public transport services. So, happening while meeting emergency section 51D. So, let us discuss here. Friends, the liability of that employer arises only if the following conditions are complied with. The insured person must be in the premises employed for the purpose of his employer's trade or business. The accident must happen while he is taking steps to rescue, succor, or protect person who might be injured or imperiled. These steps may be taken to avert an actual or suspended emergency to persons. The steps may also be taken to avert or minimize serious damage to property. So, presumptions of accident arising in the course of employment. Section 51A. If the accident has arisen in the course of employment of an insured person, then it is ensured that the accident had arisen out of employment. But this presumption is rebuttable and applied to this act only. Employer's non-liability for accident happening due to breach of regulations, section 51B. The employer is not liable for any accident even if it is occurs in the course of and out of employment, while the employee has been acting in breach of the following regulations of safety. So the insured person is at the time of accident acting in contravention of the provisions of any law applicable to him, or the insured person is acting in contraventions of any orders given by or on behalf of his employer, or he is acting without the instruction from his employer. The daily rate of disablement benefit is 25% more than the standard benefit rate. This rate is known as full rate, corresponding to the average daily wages in the contribution period. So for example, rupees 50 is the standard benefit rate for workers in the wage group of rupees 80 to 120. Accordingly to the full rate of disablement benefit, the amount comes to rupees 62.50 paise. The disablement may be temporary disablement or permanent total disablement or permanent partial disablement. For the temporary disablement and permanent total disablement, the benefit is payable at full rate, but for permanent partial disablement, full rate is not given and it is reduced in proportion to the loss of earning capacity caused by the injury. Proportionate they will give. So the in permanent disablement, the payment starts from the first day of disablement and continues for life. Here, no prior contribution is needed for claiming disablement benefit. The disabled benefit is payable to an insured person as follows. For temporary disablement, at full rate, if the disablement continues for not less than 3 days, excluding the day of accident. So for permanent total disablement at full rate, so permanent partial disablement resulting from an employment injury at a percentage of the full rate. So fourth one, dependent benefits. Friends, let us discuss now dependents benefits section 52. If an insured person dies as a result of any employment injury, whether the disablement benefit is payable to dependents or not is regulated by the provisions of one schedule according to the class 8 of section 1. If the insured worker dies, the dependent benefit is payable at full rate to the widow and children as follows. So the dependent benefit is payable to the widows during her life or until her remarriage. The amount is equivalent to 3 by 5 of the full rate. If there are two or more widows, the amount is equally divided among themselves. The widowed mother is also entitled to get to the benefits in the same manner as the insured worker's widow. So the dependents benefits is also payable to each legitimate or adopted son, the amount being equivalent to 2 by 5 of the full rate until the son attains 18 years of age. So the dependents benefits is payable to each legitimate or adopted unmarried daughter, the amount being equivalent to 2 bar 5 of the full rate until such daughter attains 18 years of age or marriage, whichever is earlier. If the total of the dependents benefits so distributed, if the total of the dependents benefits so distributed exceeds the full rate, the share of each dependent is proportionately reduced so that the total amount payable does not exceed the dependent's benefit at full rate. The other dependents are parents, grandparents, etc. They can get the benefits only if they are financially dependent on the worker. Next, friends, let us discuss medical benefits. Medical benefits section 56. If an insured person or any member of his family requires medical treatment, then medical benefit is given. It may be given either in the form of out-of-patient treatment or as inpatient in the hospital. the insured person is entitled to medical benefit during any week in which contributions are payable. The state government also arranges for medical treatment and it provides rules for the kind and scale of medical benefits. The corporation may so establish and maintain hospitals, dispensaries, and surgical services with the approval of the state government for the benefits of insured persons and their families. The corporation may undertake responsibilities of providing medical benefits to insured persons in consultation with the state government. Next, sixth one, funeral benefits. The eldest surviving member of the family, insured person who has dies in entitled to receive certain amount towards the funeral expenditure or benefits of the deceased insured person. The maximum benefit and the claim must be applied in within 3 months from the date of the death of the insured person. Benefit payable up to and including the day of death, section 71. An insured person is entitled to a cash benefit under the act up to and including the day of his death. Such amount on his death is payable to his nominee, if any, or to his legal heir. Employer not to reduce wages, section 72. Irrespective of the employer's liability to pay contribution, the employer cannot reduce the wages to his employees, whether directly or indirectly, or discontinue or reduce benefits payable to an employee under conditions of his employment, which are similar to the benefits conferred by the Act. No dismissal or punishment of the employment during the sickness period, section 73. The employer must not dismiss or discharge or reduce in rank of punish an employee during the period when such employee is in respect of sickness or maternity benefit or disablement benefit for temporary disablement, medical treatment for sickness or absent from work due to illness arise out of the pregnancy or confinement which renders the employee unfit for work. Other provisions regarding benefits. The benefits under this act are not transferable or assignable. It is not liable to attachment in execution of any decree or order of any court. If a person receive any benefit under this act, he is not entitled to receive any similar benefit under any other enactment. No person is entitled to sickness benefit, maternity benefit, and disable benefit simultaneously. The person receiving sickness or disablement benefit must remain under medical treatment and must abide by the instructions of medical attainment. He must not leave the area of medical treatment without the permission of the medical officer. So, an insured person entitled for more than one benefit is entitled to choose one among them. If the sickness is due to insanitary conditions of the factory or his house, the corporation may require the owner of the factory or the house of the payment of extra expenditure incurred by the insurance corporation as sickness benefit to the worker. The insurance corporation may recover from the employee the value of any benefit not lawfully granted to him. If the employee has died, then his legal representatives are liable to repay the amount. Dear friends, I am requesting all of you please subscribe this channel and support and give likes and comments. So thank you very much. Love you all. Thank you. Thanks a lot.